But the Chevron case, if you're familiar with that, June 28th of last year. So I finished serving all the state attorney generals on June 6th. And so you need to understand, Chevron wasn't really what we think it was. Because what's happening is that it's the prosecuting attorneys who are choosing which charging instrument to bring. Do I bring an information? Do I bring indictment? Do I bring a presentment? Which instrument do I use? And so it's the prosecuting attorneys who work for the attorney general who's making this decision. And at first glance, you would say, oh, they're the ones committing the crime. But when they choose the incorrect charging instrument because they're directed to by a state law, they're still committing that base crime, deprivation of rights under common law. But when they bring that to a judicial officer and they ask that judicial officer to please hold this person over, well, that judicial officer has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse power, who relied upon an inferior state statute to deprive a person right guaranteed by the Constitution, then he himself is depriving this person of a right under color of law, and he has now established a conspiracy to deprive rights, Title 18, 241, because of his negligence in this issue. He must make sure that the proper charging instrument is in place. And so what Chevron was that we had finished serving those attorney generals on June 6th. They were all served. We provided notice. And now, when you deal with a criminal conspiracy between agencies or between public officials, there's only two ways to get out of your culpability within it. One is you must notify the authorities of the crimes, which if you are the authority, that wouldn't do any good, which is why there's a second element, and that is you must notify your co-conspirators of your intent to no longer participate, but that must be done by some affirmative action. We must see that you did something to notify your co-conspirators that you will no longer participate. That's what Chevron is about. Chevron was the judicial branch saying, hey, this is a big deal. We're going to have to hear this because cat's out of the bag. But prosecutors, you have been bringing the wrong charging instrument. We've been negligent. Our judges have been negligent, but we're no longer going to participate because Chevron is all about, you know what, executive branch, you don't get to create law. You don't get to look at something, say it's ambiguous, and therefore choose to bring the incorrect charging instrument through your policy and then go and enforce it. That was notifying the executive branch that you don't get to legislate. You don't have that authority because that's separation of powers. So that was the Chevron. That was the affirmative action that the judicial branch was doing to notify their co-conspirators that they are no longer going to participate. Because I had already served the attorney generals and I had been producing the narrative for 7 years that, oh, it's the prosecutor's fault. Judges, you're negligent, but it's not your fault because they were doing it. But as soon as Chevron was put into place, that's when I turned around and I went and I served the same 37 state Supreme Courts. Because it's not the prosecutor's fault. It's actually the judge's fault, because the Fifth Amendment of the Constitution says no person shall be held to answer for capital N. Who makes the decision to hold someone over? That'd be the judge. So the moment that the judge chooses to hold someone over, prosecutor can bring the incorrect charging instrument. But if the judge chooses to hold someone over based upon that, it's the judicial branch that's committing the crime. But in Chevron, they have passed the buck and they've actually pointed at the executive branch and said, you guys are going to take the fault for this. And we need to find some way to be able to pit these branches of government against each other, because that's the only way we can do this. This is a monster of a case. And if we don't break up those alliances and find some way to pit them against each other, we would never be able to get anything accomplished. But when the judicial branch says, takes the narrative and takes the bait and says, oh, yeah, it's you guys' fault. We're gonna step out of this, and well, it really wasn't their fault. So now we're trying to appeal the executive branch and say, you know what, you can take the blame for this if you want, but it wasn't your fault because the judicial branch told you to do that in 1887. So what you need to do now, executive branch, is you need to notify your co-conspirators of your intent to no longer participate, so we can actually hold the criminals that are accountable for this issue accountable for it. We want to bring together these branches of government, pit them against each other, and say, I'm not going to take the fault for this. You told us to do it. And the executive branch is going to have to do that. If they don't, then the judicial branch has already placed the blame on them through Chevron. They're going to take the blame for this. And I don't know what the outcome is going to be, but what I can say is that we do have 700,000 people imprisoned right here in America today that are on direct facial constitutional violation. There's no denying that. Their arrest derived from a direct breach of a constitutional obligation, which means that everything, including the plea bargain, the trial, the sentencing, it is all void because it derives from an unconstitutional act. Any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. If you commit a constitutional violation at the beginning, then everything you do after it is all tainted by the illegality of the way it was obtained.